all the sessions are looking extremely interesting. But unfortunately, I won't be able to. Of course, I'm joining tomorrow. I have 2 sessions on transfer pricing, but this is something that I'm joining today. So what I intend doing in the next 15 minutes, and then my 3 panel colleagues will join me, is to discuss the Vodafone case in India. But more than the Vodafone case and the complex structure that Vodafone had and the principles that were laid down by the federal court and all the debate that surrounded the retrospective amendment, we are not going to focus on those aspects, but I'm just going to set the context. Instead, I'm going to focus on post Vodafone, really what happened, what kind of changes occurred in the international law. There is a very important real life case study for Sanofi, which is there before us. I'm going to discuss that case as well. Then, what are the changes that are occurring at the bilateral level is something that I also wanted to discuss. And then finally, in the last uh, 1 month or so, Vodafone has been in the news because of the Hague Arbitral Tribunal Award under the India-Netherlands Bilateral Investment Treaty. We're going to focus that as well. And here is an area where I'd like all my colleagues to join. So this is not just about what happened to Vodafone in India, but really what follows Vodafone. Please go ahead, Mary. So this is very briefly this is a simplified structure of the Hutch entity called Hutchinson SR, which has a very complex structure. There were a web of something like 97 companies about this, but this is what the structure is in India. 33% was held by an Indian group called SR Group, which were the original allottees of the license. And the balance, 67%, were held through directly or indirectly in the following manner, which has been indicated. I'm not going to go beyond the structure because that is where is hidden the 93 companies, but there is an annexure to these slides which has laid down in summary what the structure is all about. But why the structure got complex is something that we are going to talk about. Please go ahead, Marina. Next slide, please. Okay. So please go ahead, just click 3-4 times because the design of the slides is such that, we have. So this is what happened in the transaction. Vodafone, through its Dutch entity, wanted to acquire interest in the structure that I described earlier. So it paid 11 billion US dollars to HTIL, which is the seller of the shares, for acquiring one share of Cayman Island company called CGP Investments. And this company, CGP Investments, whose shares were acquired, had 67% controlling interest in the Indian license company through a web of very, very complex structure. As a result of this, Vodafone, through its Netherlands subsidiary, acquired a 50. So the 67% was acquired as follows: 52% through a wholly owned subsidiary and indirect shareholding in the Hutchinson SR company, which is the Indian company, and the balance 15% through the call options. So both 15 and 52 put together was 67% shareholding it had acquired. Please go ahead. Now, Vodafone actually in the Supreme Court argued that this isolated sale of one share did not bring any income taxable to India, and the Supreme Court agreed with that. And the Supreme Court kind of took a view that there was no provision, there was no charging provision in the Indian law that entailed taxing a transaction for acquisition of shares of one foreign company into another foreign company of the shares of a third foreign company. So the buyer was a foreign company, the seller was a foreign company, and the subject matter of transfer of shares was a foreign company. And the court went into elaborate discussion why this is not an asset located in India, why the deeming fiction will not bring that income to taxable in India and various aspects. Now, Vodafone, the law was amended, and the law was amended retrospectively, for which India acquired a lot of criticism. But any which ways, after the law was amended, the tax authorities made a claim again, saying that even though you have won in the federal court, you need to pay back the taxes. As a result of which, Vodafone invoked the bilateral investment treaty under India Netherlands. This The Hague Tribunal recently delivered an award, and by virtue of which the Vodafone, it was held that Vodafone is not liable for this 2 billion, uh, amount that the Indian authorities are asking. It went ahead and said that under the India Netherlands bilateral investment treaty, the amendments that were made to the Indian law pursuant to Vodafone winning the case was in breach of the fair and equitable treatment under the bilateral investment treaty. The award was not in relation to a tax arbitration, it was an investment treaty arbitration. Several questions have arisen. This is not the first time that a award has been given under the bilateral investment treaty, but this is the first time an award has been given under bilateral investment treaty, but in relation to a tax claim. And the issue that is currently alive is what should the Indian government do? What kind of right does it have to appeal? And it is examining all the options, including appealing in a Singapore court against the arbitral tribunal award of The Hague. Now, there are many questions that arise which we are going to debate in the panel. But before we get to debating in the panel, I just wanted to lay down some of the other relevant cases as well. Number one, should the arbitral award be appealed in an Indian court or in a Singaporean court? In the meantime, a related development took place where uh, before the Hague Tribunal gave the award, a state court of Delhi allowed Vodafone's plea and said that since Vodafone is in dispute before an international arbitral tribunal, and that dispute will be governed by a public international law and not by a local arbitration law in India, the tax authorities cannot raise any tax claim up until the International Arbitral Tribunal awards it. Now, this particular direction of the State Court of Delhi was not on the merits of the tax case, but merely suggestive of the fact that no action should be taken by the revenue insofar as the tax claims are concerned. Now, the award given by the Permanent Court of Arbitration under the treaty is clearly not a foreign decree. And this is something which is specifically been provided for under the Indian Civil Procedure Code. And hence, a high court in India does not technically have a jurisdiction over a Permanent Court of Arbitration award. This position is also very clear. Now, India may repeat the question on jurisdiction of the Hague Tribunal's award over the tax dispute on the ground that tax disputes are typically not covered under the bilateral investment treaty. Now, the decision to honor the award is clearly going to be a political decision. It depends on what India is doing. Even today, the Additional Solicitor General issued a statement that the government has not decided eventually what it is going to do with the award, whether it is going to agree with the award or it is going to appeal against the award. So this is a live issue as we are speaking today. It's just few hours back that the Additional Solicitor General issued a statement to this effect. Next slide, please. Now, let's look at what are the implications of the Vodafone case. Some of them are live implications. Please go ahead. Now, one is a Sanofi case. Now, the Sanofi case, interestingly, was a case where there was a similar transaction at an offshore level, but the structure for Sanofi was very simple. There were two French companies, Biomerix Group called Merix Alliance and Dassault Group, which is the industrial group. They were holding 80 and 20% respectively into another French company, which was a joint venture. And that French company, in turn, was holding an interest in an Indian pharmaceutical or a biotechnology company. Now, the deal was as follows that Sanofi, as the new buyer, brought out the 80 and 20% stake from Biomerix and Dassault Group. And there was no change insofar as the ownership of the French company in the Indian company is concerned. The tax authorities brought out a claim saying that this is taxable because there was a ruling which was sought by Sanofi, whether this particular sale of shares will be covered under Article 14.5 of the India-France double tax treaty, and is the transfer of a controlling interest liable to be taxed in France under Article 14.5 or under Article 14.6. The Advanced Ruling Authority clearly said that post Vodafone and post the amendments to the law, it is very clear that this company, Shan H SAS, which was acquired by a new buyer, has an underlying asset in India and to the extent of 80%, and hence this transaction is taxable. There was absolutely no doubt as regards taxability of this transaction under the domestic law, but the questions that were posed were under the international law, which is the treaty law, specifically the treaty between India and France, and the concerned articles were Article 14.5 and Article 14.6. Next slide, please. After the decision of the Advanced Ruling Authority, Sanofi appealed against this decision to the Andhra Pradesh High Court. And the questions before the High Court were whether the sale of underlying assets is liable to be taxed under Article 14.5, or whether the controlling interest in the Indian company, which was transferred to Sanofi, was liable to be taxed under Article 14.6. And it also raised a question on interpretation of the term. What do you mean by saying alienation? And alienation of shares is a specific article. Now, Article 14, subarticle 5 deals with alienation of share transaction. Article 14, subarticle 6 deals with other forms of assets. Now, the High Court took a view that insofar as Article 14.5 is concerned, it is very clear it has to be alienation of shares in a company. It was not alienation of shares in the Indian company that was a subject matter of transfer. It was alienation of shares in the French company. You cannot apply a see-through approach and say you're going to ignore the French company and look at alienation of shares in the Indian company. And hence, there was no question of applicability of Article 14.5. And since there was no question of applicability of application of Article 14.5, the interpretation of whether this is an other asset under Article 14.6 is academic. However, the court went into fairly detailed arguments that when you interpret the term alienation of shares, whether you can rely on Article 3.2 of the Double Tax Treaty, and Article 3.2 of the Double Tax Treaty talks about situations where terms are not defined in the treaty, and you need to look at the domestic law, because what the Indian revenue was relying on is that the definition of what is alienation of shares under the Indian domestic law is very, very wide enough. Next slide, please. Now, the Sanofi case is before the Supreme Court of India. In Sanofi's case, the view that was taken by the Andhra Pradesh High Court is that this was clearly not taxable under Article 14.5, and the revenue's reliance on Article 3.2 to look at the definition of the term alienation under the domestic law is ill-founded. Now, this is one case law that we have put it out just to be able to explain the extent of the Indian law and the reach of the Indian law. This pertains to a UK company. It's a PLC company. It's listed on the London Stock Exchange. It is incorporated in Luxembourg. All the assets and liabilities of the UK company are to be transferred to a Luxembourg company. This transaction is tax neutral in the UK. Now, the UK company has two forms of shareholders. It has a shareholder group in Belgium, it has a listed company in India, and it has a private company also in India. And what the shareholding pattern of the UK companies concerned, what is below the UK company is also given. The shareholders of the UK company are not in any manner impacted. So when there is a internal reorganization by which the shareholders of the UK company become the shareholders of the new co, which is the Luxembourg company listed in Belgium, there is no impact insofar as the shareholders are concerned. However, after the Vodafone law, some key questions arose, and these key questions were specifically in the context of individual shareholders of the UK PLC, who have now become individual shareholders of the Luxembourg company, because these individuals were a part of the family foundation. Some of them were holding shares in their individual capacity, some were holding through trust. However, the combined holding of this class of shareholders was 5% in the UK company. And that is also the threshold that has been prescribed in the Indian domestic law. So the key questions that arose or that arise in this case study is whether the shares that are held by individuals in the new co will trigger any capital gains tax under India's indirect transfer law. Second, whether for the purposes of determining the value of the underlying assets of the UK PLC company into the Indian companies concerned, how do you go about doing that? There are specific subordinate legislations in India to deal with that, but that's not what we are concerned with. And how do you define the term transfer? Is the term transfer under the Indian domestic law means exchange, extinguishment, and whether the internal corporate reorganization of the UK company is resulting in extinguishment of rights of the shareholders or exchange of right of the shareholders. So this transaction may be exempt from a UK law perspective. But if you look at it from an Indian law perspective, there is a transfer because the rights of the shareholders are getting extinguished. Next slide, please. So we've not answered the question, but I'm just trying to say that these are the issues that are going to come about. Now, finally, I'd like to just present some of the changes that are occurring in the international landscape. One is the proposed UN provision in Article 13 of the UN model. This proposal essentially deals with extension of the UN clause, which deals with transfer of immovable property by the transferring shares of the company, where you are looking at the situs of the property in order to levy capital gains, both under the UN and on the OECD model. Now, indirect transfers as such specifically is not covered in the OECD model, but UN intends bringing such form of transactions within the tax net of the source country, such that the case that I explained to you in the context of Sanofi will be liable for tax. Now, this new sub-article has proposed that under the UN model, such offshore indirect transfer of shares, it says OIT, offshore indirect transfer of shares in a third country, will get covered to be able to tax Vodafone kind of transactions, not just under the domestic law, but also under the treaty law. Of course, it'll all depend that when this UN model is agreed upon, that countries will have to enter into this particular article as a part of the bilateral treaty. But this is just suggestive of the move that is being taken at the UN level. Next slide, please. Now, the recommendations of the UN model are coming with certain safeguards. I'm not going to go into the safeguard, but suffice to say that there are some safeguards which are also aligned to the domestic law in India. Number one, that the valuation of the underlying assets should have a threshold of 50%, which is also there under the Indian law. Uh, but the rest of the safeguards that UN model is proposing are unique to the UN model. Those safeguards are not there under the Indian law. So in a way, the UN model is a uh, more refined model than the Indian domestic law. For example, the Indian domestic law doesn't have an exclusion for intra-group transfers, like we looked at it in the context of the example earlier, or for that matter, any reorganization which is of a listed company. It doesn't have a 20% shareholding of the offshore indirect transfer. Uh, it doesn't have grandfathering provisions. It doesn't have the 365-day conditions for transfer of ownership. But these are the safeguards which are there in the UN model that is being recommended. This is not important, but my idea to put out this slide was to be able to explain what are the typical uh, landscape changes, if I may say so, are occurring as a result of the Vodafone case law. So let me pause over here. I've taken more time, 7-8 minutes more than what I was supposed to be. Hans is now going to assume control of this. So Hans, your first take on you know uh,
Just
international implications on a host of issues. Can a BIT be given in the context of tax? What do you see as the future of the UN model? Will
uh,
OECD ever embrace it? So, the floor is yours, Hans.
Mukesh, you know better than anybody here that India has an extremely important influence on the UN model. It's already going on for years, and actually, there seems to be like an Indian model tax convention, which seems to be getting leading in countries around the world. So, from that perspective, you see the influence of India very much here. A few remarks is that I am afraid of the following situation. Depending on how this is going to be implemented, you get the discussion on dynamic versus static tax treaty interpretation. If there is a new provision in Article 13, then a dynamic tax treaty interpretation is difficult to do. However, I know that still states probably are going to take that position. It's the same with 12A of the UN Model Tax Convention. I believe India also said we don't need to implement 12A because we do it anyhow. We apply. So this is probably one of the things is going to be quite important. UN it's again more source state taxation, and yeah, that's a trend in international taxation. So I'm not fully sure whether when this is going to be accepted. I think it's going to be accepted by a lot of states because it's a new opportunity for them. Still, the discussions will go on and on with the OECD model tax treaty states. How uh, will there be new renegotiations? Will they accept this? I don't know. I recently there was a tough discussion between the Netherlands and Russia, where Russia actually wanted to include in a new treaty many new provisions which were just not acceptable, and the Netherlands rejected the proposal of Russia. And I really believed the Russians are now going to get very difficult, but it didn't. They started new renegotiations. So, but just, we just don't know how this is going to work out. But I wanted to add a few things about bilateral investment treaties, because there is a lot of things going on. Actually, the BITs are experiencing the same things which we experienced since 2012 in international taxation. A few things to mention here. The bit is being used, and if I recall well, it's now with the appellate body in Singapore for the next phase arbitrage. But it's based on the bid between the Netherlands and India, and it was a golden system we have in place in the Netherlands. The Dutch model bilateral investment treaty was a model for the world. Germany and France, specifically those states, always said this is as it should be because it safeguards foreign direct investment in other states, and therefore it's very, very, very important. And then we got CETA, then we got TTIP, and then we got some other multilateral treaties in the world. And Mr. Piketty from France with his book about poverty. And then we saw that the debate on bilateral investment treaties was captured by the NGOs. And besides that, within the European Union, we had the Achmea case where the European Court of Justice said, all these arbitration courts, we don't perceive them as courts. They are not perceived as courts, and therefore only the European Court of Justice is decisive here. It's the Achmea case of the European Court of Justice. But the NGOs, they hijacked the whole debate on bilateral investment treaties, and now there is, since 2018, a new model from the Dutch bilateral investment treaty, which is of course only applicable for those states with which we renegotiated the model. With India, for example, it was terminated already in 2016. So currently there is no bid working. But in that new model, there are some extreme positions being taken. For example, expropriatory, difficult word, is not being safeguarded by the bid anymore. It's just excluded. And besides that, the bid for the Dutch model bid is only applicable for companies which have substantial activities. So in the past, even letterbox companies could apply a bid. Now, in the new system, you have to prove that you have substantial activities in the Netherlands in order to use that bid. And last remark, because Fernando is also waiting to give his words. A last remark from my side is that besides this whole discussion on bids, there is another position that in 2012, the European Union member states gave authority to the European Commission to have the last say on any bid with third states which have been concluded by EU member states. And they do this because they want to make sure that bids are not going to interfere in TTIP and all kinds of multilateral international tax treaties. And then, so this makes the whole process for bids in the future quite difficult. And one final remark, Fernando, and then I give the floor to you, is that also in the Dutch bid model, what you see is a provision which states that you have to commit as a company, if you want to use the bid, that you will fully apply all corporate social responsibility rules which can be expected. So diversity, no discrimination, etc., etc. And you have to fully apply the OECD model tax transfer pricing guidelines continuously. Goes for the non-legal part as well as for the legal part, which makes it very difficult to apply the bid. So the future for bids is quite negative. Like with international tax planning, the same kind of reasonings are behind this. The NGOs played an excellent role in making this a wreckage kind of a situation. Fernando, perhaps to you.
Yeah, thank you. I'm surprised by the all the topics described by Mukesh about the indirect transfer, because we are very far away from India here in Latin America, but we share a lot of the same problems and the same issues, right? We have our own Vodafone case in South America, actually in Peru, in my country. It was called the Petrotech case, in which a very large oil company was indirect transfer from an US shareholder to a Colombia and Korean national oil company. And that case start all our road in the indirect transfer, not only in Peru but in Latin America. Peru, as a consequence of that case, introduced indirect transfer rules. Also, then come Chile and Colombia. These three countries has already introduced indirect transfer. The problem is that each country, they don't have the same approach. They have different approaches. For example, in the case of Peru, the rule is only applicable if the value of the offshore company, of the non-resident company, derived from shares of Peruvian company. But if it derived from other kind of assets, including immovable property, it is not applicable. Colombia and Chile has a different rule. And if we are dealing with international reorganization, for example, or indirect transfers, we have to consider that each country have different rules, and that is really complicated. I have been part of this kind of transactions, and even in internal reorganizations, and the difference are really huge between each country. Uh, Other point that I want to remark is about bits. I'm kind of worried about your last conclusion about bits, because in general in Latin America, it is very difficult, I would say almost impossible, to have to win a case. If you are dealing with a large case, the pressure of the government is really very, very strong, and it's almost impossible to have to win, right? To have a successful outcome, either at the administrative stage or even in the courts. We have seen in the last years a lot of cases in which the discussion was not technical. At the end, it was a political discussion about taxes, and the technical issues were not considered. And on that scenario, the importance of having access to bids for foreign investors is like the last resort. Okay, and our countries has a lot of bids. Each bid, as you said, is different. But if the scope of these bids are going to be limited, restricted in the following years, then we will have problem to have justice over tax issues in our Latin American countries. So
I can see that,
I'm kind
Fernando.
of concerned about that.
What I can add here is that any bit which doesn't expressly exclude tax issues is applicable, and therefore in your situation, if for example in the Dutch Peruvian bilateral investment treaty, it's not excluded, it's applicable. Existing treaties will still being applied, which means that you can still go in any case for the PCA, or there are several ways to go in an arbitrage situation. Of course, it's still possible. It will only end at the moment that has been taking place a renegotiation between the Netherlands and Peru, and I
Right.
assume if that the Peruvian government is going to accept a request from the Dutch government to dive into a new negotiation. But still, we have a couple of years' time. And of course, it's all about when does the case arise. So suppose that we would have renegotiation this month and they will conclude it's not possible. A new bid in December, and your case is from 2018, it will still be possible to deploy the bid. But it's going to, for the future, it's going to be quite difficult, and it's unbelievable actually that it goes this way. The new, if you need an EU member state for protection according to the bids, the Belgium and Luxembourg bids are a little bit more flexible than the Dutch one. But what you really want to achieve, that you can bring a tax case to arbitrage, is also there quite difficult, unfortunately.
Thank you.
Yeah.
Nupur, you have any quick comments? I'm just got a message that this will be automatically switched off in 4 minutes time, so because that's the only allotted 45 minutes for us.
Yeah, I would just like to add from India point of view, even from India point of view, and I see more and more countries have started reviewing their bilateral investment treaties because of more and more cases coming up. In India also, we have now a different model treaty which India have framed, and we have specific tax carve out which specifically make sure that tax cases are not covered. Of course, for the past cases, we still have to go through the old treaties, but for new India, and earlier there were 80 tax BITs, now we have only 14 BITs currently in force. So yeah, the future of BIT is still in question, and there are a lot of open questions from Vodafone case also regarding enforceability. I think we are short in time to address all those questions.
At this moment, there are, but just for fact finding, there have been decided less than 40 bid cases worldwide on tax matters, and approximately a little bit more than, I believe, 21 are decided in favor for the taxpayer.
Taxpayer, yeah.
Yeah.
So the majority is still won by a little bit of majority by the taxpayer.
Yes, that is what I was also informed, that the data suggests that the half of them have been won by the taxpayers and half of them have been lost by the taxpayers. But it'll be interesting to see how this case is considered from a enforceability standpoint, because as we are speaking, one more bit award under the India-UK treaty with regard to a tax claim for a Edinburgh-based listed company called Kane Energy, where the arbitration proceedings were actually completed even before Vodafone, but that award is awaited. And that's also another award that will be looked forward to. But I'm told that there are at least 8 to 9 more cases arising out of tax claims. And all of this, Nupur, are in relation to the old bits before they were cancelled.
Do you think, Mukesh, that this decision will have implication on those upcoming decision of Kane or other Nokia?
I don't know. I think it'll be too speculative to comment on that. One reason I can't comment is I have been involved in some of the latter cases. So in a way, I'm conflicted from saying anything. But I think that each of these cases will be decided on the facts of their own case and on any legal principles as such. So, you may very well have one case decided on facts in favor of the taxpayer and on the other against the taxpayer. I don't think that there's going to be any general principle that will be propounded. But what will happen in Vodafone cases, which is the reason it is a test case, is that the enforceability part will be determined in the Vodafone case, because that will determine how India looks at it for enforceability in the future.